Okay, some possibly good news about the single justice procedure, albeit with a bit of a caveat. So what am I talking about? I've done some videos on the single justice procedure before, and if I can remember, I'll link them in the end screens. But essentially, that's that procedure that is used where a prosecutor decides that an offence isn't likely to attract prison. So they give the defendant the opportunity just to have the matter dealt with in writing. Um, and they send their paperwork off. They indicate a plea and send it off, and it goes in front of a single magistrate, hence why it's called the single justice procedure. But the problem is, it's one lay magistrate. They are assisted by a legal advisor, but there's a new pilot scheme which will probably be, extended, where it's three or four magistrates sharing a legal advisor. So they just ring them up, and people have already been saying there have been problems getting in touch with them. But we've seen all these problems where clearly people who shouldn't have been prosecuted were convicted, where they had defences. There was that poor girl where she didn't have capacity, and the council had forgotten to pay her TV licence for her because they ran her finances, and she was prosecuting. The council just entered a guilty plea, and fairness to the magistrate, they didn't know that was the thing because they just got a form saying she pleads guilty. They didn't know any of the background circumstances. And similar things with like people with who've been looking after their wives with dementia. Their car's been off the road for years, but they've forgotten to saw on it one year. All this sort of thing, and it's the fact that the procedure is this is just done in a room somewhere. It's not open to the public or to the press. So it's very hard to know exactly what is going on. So, what has happened? Well, the Magistrates Association have actually they've recognised the problems and put forward a series of recommendations as to how to address some of these problems. And I'll go through them because I think you'll be interested actually in the detail, because I've seen from your comments, these are a lot of issues that people have raised in the comments. So let's go. First of all, they recommend it becomes a requirement that the prosecutor see all pleas and mitigations before the cases are heard by the magistrate. This would give the prosecutor the opportunity to see and read the mitigation and to withdraw the case if they believe it is no longer in the public interest to pursue it. Because again, that was a problem. Because the way the system was set up, people were sending in the official paperwork, but then putting in sort of, more explanations or pleas in mitigation or letters in support or letters of explanation. And they just weren't being seen by the prosecutor and subsequently not being passed on to the magistrate. So this is now saying that, the prosecutor has to be able to see everything that the defendant has sent in. And the next one, SJP training should be formalised and specific to the process, and it must emphasise the ability of magistrates to use their discretion fully and without reservation, including the ability to refer cases back to the prosecuting authority. So what they're saying there is, look, you're the judges. It's not just meant to be a tick box exercise. Tell people, you don't just have to go, oh, there's a form here, they must have pleaded guilty, I'm just going to give them X number of points and this fine or whatever. They're saying, read the material, and if you're not happy with, what's come from the prosecution, treat it like a real case. Well, there's not enough evidence here. Don't be afraid to send it back to the prosecutor and say, there's not enough for me to work with here. And it's saying also there must be a review of both the training provided to the legal advisors and of wider policies surrounding SJP to ensure that they do not unwittingly put magistrates under any pressure to complete a certain number of SJP cases within a certain number of time. So, like I say, the magistrates, because, they're just lay people, they're just volunteers. They don't get paid other than their expenses. So they rely on the legal advice, for the law, on professional lawyers, the legal advisors that are attached to the courts. But they're saying here the legal advisors, need to be explaining to the magistrates, look, don't feel under pressure that you've got to get through all these. Because this is what happens. It's all bulk cases. They'll just dump 200 files with a magistrate and say, get on with those in your own time. And that's what's happening. But the idea is that there's internal sort of pressure to say, look, we're trying to clear a backlog here. I mean, so many cases every year are dealt with under this procedure. Also then, to sit alone on SJP cases, magistrates should have passed their threshold appraisal and sat for at least an additional year in an adult criminal court to ensure they have the right experience and confidence. Because that was another problem. It's like, right, you're the new magistrate. How do we, break you into it? I know, we'll just sit you in a room and you can go through all these cases. So, the idea is actually, no, you want the more experienced people dealing with this because, there are no lawyers present. There's nobody from the prosecution to explain the details of the case. And there's nobody on the defence side to sort of put forward the defendant's arguments or mitigation. The government should make provision for SJP sittings to be observed by accredited journalists. So, it's all about the transparency because, nobody even knows, where these are taking place. It's like there'll be a room in the court somewhere, but it's up to the magistrate as to when they come in and when they do it. So, there's no oversight. It'll be interesting, though, to see if there's a argument there because we've had this before about is there actually any difference in law between accredited journalists and anybody else, citizen journalists? And it's very nebulous. Perhaps I should do a follow-up video on that, actually. The Transparency Working Group, recently set up by the Lady Chief Justice, should include the SJP in its considerations. That's a sort of wider scheme, to open up the courts a little bit more, demystify them. Because there's things like in family proceedings now, journalists are allowed to, come into the hearings and take notes. Because previously, that it's always been argued they should be confidential because, obviously they're dealing with very sensitive matters. But the idea is, look, properly trained journalists can be trusted to report these sensitively and without breaching any confidences. Speaking of journalists should be able to see short explanations from magistrates where the magistrate has deviated from the sentencing guidelines. This will in turn help the public to understand why a particular decision has been made. It also aligns with the duty to give reasons in open court. Whilst this will inevitably slow down the process, it is an important safeguard. Because that's the thing, you see, when it's dealt with normally by SJP, all you get is a notice from the court saying it's been dealt with, here's the fine that you owe, or here's the points going on your licence, or here's, the length of your ban. Although usually in traffic, if they're thinking of a disqualification, they actually say, no, we'll do this in open court, so you can come along and argue about it. But yeah, this is, the idea now they have to give reasons. Now, it's only if they depart from the sentencing guidelines, because I suppose the rationale is there. As I've mentioned before, as a judge friend put it, it's sentencing by spreadsheet. So if you look at these sentencing guidelines, and they are available online, it's like a big spreadsheet, and you literally just go through and, if we tick this box, and this box in aggravation, and this box in mitigation, and it's this category of offence, and it's this level of seriousness, here's the range of sentences, apply all this formula for discounts or when the guilty plea was. I mean, it really is that formulaic. So the idea is, I suppose, if it's a sentence within the sentencing guidelines, it's self-explanatory as to why it was passed. So you only really need an explanation if they depart from that. So I can see that makes sense. Just saying, the court service and the Ministry of Justice should just publish more data on the SJP, such as how many defendants plead guilty, how many no pleas, how many go to court. This could provide an indirect measure of defendant engagement with the process and could be scrutinised by the media and the public. So yeah, again, it's all this idea of openness because, it is very hard to find these figures. I did that link previously to the relevant website that's supposed to show the results, and people were just saying half the time it wasn't working. Further research on how to undertake improvements to the process. The court service should work with prosecuting agencies to review the paperwork sent to defendants to make it simpler and easier for them to understand. And also they should try to get one of those crystal marks, for plain English. Now here's one that the devil's in the detail. that consideration be given to a link between HMRC payroll or benefits data and SJP, removing the need for a means form to be submitted by the defendant. So the argument there is, because when you send all the paperwork back, you put in a sort of, income and expenditure form so they can work out the level of fine. But what they're saying is now is, oh, you don't need to do that. We'll just set it up so we can just look, at your tax returns, or we can look at your sort of, with the DWP, what benefits you're on. I mean, I can see some arguments there about sort of, data protection and privacy issues. So it'll be interesting to see what happens with that one. I think if you ask most people, they'd rather fill out the means form than just hand over all their personal sensitive information. And the final one, we would like to see a concerted effort to publicise the importance of responding to official court letters. This must also make the rights of the defendant clear. For example, that they can opt out of the SJP and ask for their case to be heard in open court. So two things there. I mean, like I say, a lot of people are convicted without even knowing that, something was afoot. Sometimes that is because letters go astray or things like that. But sometimes it's just, they didn't really realise what was going on. They got a letter from the court, possibly ignored it, or sent it back and then just, didn't think about anything. And, the first thing that they realise what the implications were is when they get a letter from a court saying, congratulations, you're banned for 6 months and you owe us £500 or something like that. So, it's just to highlight and say, look, you need to engage with us. So, we don't just deal with you in default, but also just make it clearer. You don't have to go through this procedure. You can just say, I want my day in court. And that's whether you're pleading guilty or not guilty. I mean, sometimes I've done that with friends with traffic things and said, look, I think this is going to come better for me, than from a letter. Sometimes it is the other way around, though. You just go, look, let's just stick all the paperwork in and hope they don't read it too closely. But anyway, there you go. Like I say, what's the caveat? The caveat is the government were asked relatively recently in a parliamentary question, and they said, what are you going to do about all these problems with the single justice procedure? And the one-line answer was the government has no plans to change the procedure. It might, however, be, I mean, that's clearly shown, they're not bothered about this, but it might just be now that all the magistrates and some senior members of the judiciary are sort of now rocking the boat. But it'll probably be like the post office. It will take more of, the scandals just going out in the media, I think, before people go, wow, what's going on here? So actually, a guy called Tristan who writes the Evening Standard, and it's one of his articles that alerted me to all this. So, do feel free, if this is something you're interested in, to, follow him on Twitter or something like that. But anyway, there you go. Hope you found that vaguely interesting, vaguely useful. I would say vaguely accurate, but I was reading off some notes. If you did, please consider liking, sharing, subscribing, YouTubey things. Chaps, say hello. And now I'm going to stand here. I'm not going to pull a face, but I said I'd link to my previous SJP videos, didn't I? So if I go, here they are, and sort of just hold that for about 10 seconds, then by the magic of the internet, they should be up there. I can also pull some faces for the thumbnail. I do apologise for all the face pulling and the clickbait titles, especially to the Princess of Wales. But, it's just for the algorithm. It's ridiculous. And the Princess of Wales thing, well, I'm just killing time. It's really weird, that, because, do you know, if somebody says turn of the century, I still think 1800s to 1900s to 2000s. It's always the first thing that gets in your head. It's like, to me, if you say Princess of Wales, I think Lady Diana, which again is sort of out of date. But there you go. Let me know in the comments if that's something other people experience or it's just me getting older.